aimed at mitigating the suffering which inevitably occurs during armed conflicts. Informers or collaborators do not feature amongst the categories of persons which the law formally recognizes during armed conflict, principally combatants, civilians, prisoners of war, the wounded, sick and shipwrecked, medical personnel, spies, and mercenaries. But just as the maxim inter armes leges silent is no longer accurate, neither is it the case that the laws applicable in armed conflict ignore wartime collaboration, including the use of informers. How the laws of armed conflict address the practice of informing and other forms of collaboration during conflict is the subject of this book. International law recognizes the widespread and enduring phenomenon of individuals cooperating with an opposing side during an armed conflict, but treats it with some ambivalence. The lawfulness of resort to the practice is generally accepted in principle, yet international law seeks to place certain limits, including restrictions on the methods employed in the recruitment, use, and treatment of informers and other collaborators during armed conflict. Much as international humanitarian law eschews consideration of the lawfulness of the use of force giving rise to conflict, focusing instead on how parties to an armed conduct themselves, this body of law does not generally pass comment on the legality of recruiting and using informers or other collaborators, or the lawfulness of individuals engaging in certain forms of cooperation with an adversary, but rather concentrates instead on the treatment of individuals considered as actual or potential collaborators. The limitations imposed are in recognition of the harms frequently associated with the practice, which is itself considered as acceptable under prevailing international law. International law has broadly adopted a permissive stance when it comes to wartime collaboration. When the Swiss jurist Emer de Vattel considered the question in the mid-18th century, he concluded that measures encouraging an enemy's subjects to collaborate are not contrary to the external law of nations, nor can the enemy complain of them as odious proceedings. Accordingly, they are practiced in all wars. In the specific realm of wartime intelligence gathering, the 1907 Hague Regulations permit the employment of measures necessary for obtaining information about the enemy and the country. The United Kingdom Joint Service Manual states that the gathering of such information about the enemy is not only permissible but essential, and it specifically envisages the use of collaborators and informers for this purposes. Intelligence can be gathered through the employment of informers or agents in enemy-held territory, while it is lawful to employ spies to induce enemy civilians or soldiers to give information, or to give false information to the enemy. International law has not completely forbidden the use of the enemy's population and personnel against it. On the other hand, international humanitarian law can be seen to place some limitations on the use of informers and other collaborators, including restrictions on the methods of recruitment and the treatment of persons that may have served an opposing side. The Fourth Geneva Convention of 1949, for example, sets out that no physical or moral coercion shall be exercised against protected persons, in particular to obtain information from them or from third parties. As will be discussed in this book, the recruitment of informers and collaborators has frequently, although not always, involved the employment of coercive measures. It is the treatment of suspected informers and other collaborators by the aggrieved party, however, that has almost invariably involved the most cruel and vengeful actions. Parties to an armed conflict show little mercy to those who cooperate with an adversary, often subjecting them to ill treatment and extrajudicial execution. Informers and other collaborators tend to fare far worse than captured members of opposition forces, both during and after a conflict. As the influential Lieber Code of 1863